Hello and welcome back to EZTexasDivorce.com. Today I'm going to be taking you through the process of a divorce or a custody case. Now, the custody and divorce cases are very similar. The only difference is that one's called a suit affecting the parent-child relationship and the other is called a divorce. And in the divorce, you'll be adjudicating a few other things, such as the distribution of the debts and assets in the marriage, and whether there's temporary spousal support or spousal support ordered after at the final hearing as well. But in a suit affecting the parent-child relationship, those two issues are not addressed. But the similarities are many in those two different cases. And the two main similarities and the most important ones, which I'm sure you could guess, are number one, the possession and custody schedule of any children that are subject to the lawsuits. And then the second would be the child support. And what also goes along with that first issue are the other rights and duties that go along with the right to parent the child. So if medical decisions are very important to you or either one of the parties, those often can be litigated quite a bit. But anyway, with no further ado, let's just jump into the initial process. So let's say that you call up your attorney and you say, hey, Cody, I need a divorce. And I say, great or not great. I'm sorry to hear that, but I'm here to help you. And so what I want to do is get some information from you, and it'll be very similar to that first video. I'll actually go through the intake form with you, or I'll have you fill it out on your own, whatever you prefer. But in that form, if you've got kids involved, there are quite a few questions regarding the kids. There's also questions relating to the assets and debts of the marriage if you were married. And then if you are just doing a suit affecting parent-child relationship, then it'll just be restricted to the kids. So let's go through that process. So the first thing we'll do is we'll draft the original petition. So it'll either be a divorce or suit affecting the parent-child relationship. We'll get that filed, or you'll file it on your own depending on your package. You'll serve it, or we'll serve it. And then we'll set a hearing with the court coordinator, and by statute, a temporary order hearing must be heard within 14 days. A temporary restraining order hearing must be heard. And so we get in front of the judge very quickly, and often we'll deal with the temporary restraining order and the temporary order hearing in one meeting in Tarrant County. Some of the other counties don't have that emergency temporary restraining order hearing. But you will eventually and pretty quickly usually get in front of a judge regardless of the county you're in, because we need to get a ruling from a judge that says, well, these are going to be the rules that y'all play by until we enter a final divorce ruling or a final parent affecting child relationship case ruling. And so it's very, very important that we get all of the information added to that intake sheet right from the get-go. We need to know what's the worst thing that the opposing party is going to say about you. What's the worst thing that you can say about the opposing party? What's your ideal outcome in this case? What type of standard possession schedule do you think would fit best for the opposing party if you're looking for primary? Or vice versa. If you're let's say your dad and you don't want primary, then what type of schedule would fit well for you? Or if you're a mom and you didn't want primary, what would be the best schedule for you? And so let me go through a couple of those questions real quick. So the standard possession schedule order in Texas is as follows. So you would have, if you were the non-custodial parent, you would typically pay child support, and then you'd have access to the children or child on the first, third, and fifth weekends of the year. That starts at 6 p.m. on Fridays and ends on Sunday at 6 p.m. And so first, third, and fifth weekends, you get 30 days in the summer. You have until April 1st to designate how you want those days split up. So if you want to do 2 weeks in the beginning, 2 weeks at the end, you need to designate that by April 1st. And you also get to rotate the schedule of the remaining holidays. So you would do Thanksgiving and Christmas and spring break rotating. And Christmas switches every year on the 28th. So if you have Thanksgiving one year, then the other party would have Christmas, and then you'd switch on the 28th. So you'd have New Year's. And then spring break obviously rotates. So that's an overview of the standard possession schedule. There's something called extended standard possession, which I often recommend to clients. It's a really, really nice feature. It adds more days and it allows you to put your eyes on your child or children for approximately 47% of the year. And so that schedule is just like the standard possession schedule, except you add in, instead of picking the children up on Friday, you'd actually pick them up from school on Thursday. And then you'd bring them to school on Friday. And then you'd have you pick them up from school on Friday. Then you'd have Friday, Saturday, Sunday night. And then you'd bring the child or children to school on Monday morning. So it adds those 2 extra days. It adds that Sunday night and it adds that Thursday night. And lots of clients really, really think this works well for their schedule. And sometimes it's worth, if you're not looking to have a drawn out custody battle, and basically you end up getting 47%, which is close to 50%. And so it's something that we really highly recommend if it's the right thing for you. Of course, it's your decision ultimately how you want to proceed. You are the employer, we are the employee. But it is something that you can think about, and you may get the other party to sign off on and save you some money from having to go to a final trial. And so let's jump back into the temporary order hearing. So after the documents are filed and served, we get ready for that temporary order hearing. In that intake sheet, I ask questions like the worst thing that the other party will say about you, worst thing you can say about them. There's also questions about who takes the children to the doctor, who prepares meals for the children, who bathes the children, who is the primary caretaker of the children. Because the test that the court will use when determining custody is the best interest of the child test. So what we want to show is that, yes, if you're seeking primary, that you are in fact the one that's acting in the best interest of the child. Now, there are ways to overcome if you are, for example, if you're dad and you work and mom takes the child to the doctor. Well, there's ways that we can overcome that, but it is something that that courts will look at, because after all, someone who's taking the child to the doctor is acting in the best interest of the children. So that is what we'll start spelling out. We'll also ask you to take pictures of the child's bedroom. We'll ask you for information about their sleeping arrangements. We want to paint a picture for the judge, because after all, the judge has, in Tarrant County, each judge has about 3,000 cases on their desk. And so we want to paint a picture for the judge about who they're dealing with. And by sending and submitting pictures at trial, that gives them an idea of who these folks are. And yes, if I'm awarding the primary custody to Mr. Martin's client, that they're going to be in good shape. And so that's one of the ways that we do this. Now, we also ask you to upload text messages and any sort of information and evidence that we can use to show that one of the parties, the opposing party, is acting unreasonable or not in the best interest of the child. So evidence of CPS cases being opened against the opposing party, drug use by the other party, whether they can pass a drug test or not. We often request nail drug tests at the temporary order hearings, and those can typically go back for 3 to 6 months. We can also request hair tests, hair follicle drug tests. We can also do other tests as well. But it's good to know going into that hearing what you want achieved, and that's why that intake form is so important. Now, we also ask whether Whether you have any other evidence, any pictures, if there's ever been any sort of domestic violence, that is useful both in a SAPSR, a suit affecting parent-child relationship, or a divorce case. Uh, we want to, if someone's beating up on one of the parents in front of the children, obviously that's not good for the children. There's also ramifications for a married couple. So if there's been domestic violence, if there's been cheating, if there's been inappropriate actions taken by the other party, well, then that can be used against the other party when they do the final hearing, when they're dividing the assets in the community division. Another thing that we like to get into in the beginning is whether one of the parties has wasted community property assets. So the wages, once you're married, the wages that both of you earn become community property. So if one of the parties is off spending money on a paramour or a girlfriend or a boyfriend, something like that, that's going against the interests of the community estate, well, that may trigger pleadings that we request that the community estate gets repaid. But there's a lot that goes into that. So the intake form is really important, is what I'm getting at. Now, that temporary order hearing, the first thing that will happen is if we do want drug tests to be conducted, then we'll show up to the hearing, we'll request drug tests. The judge will typically order those drug tests, and then we'll come back in 2 weeks after the tests, and then we'll show the judge whether they're positive or not. And the judge will get a copy. And often, if you think that the other party may be doing drugs, well, we recommend pursuing a drug test because that really helps your case. It takes the judge's it really takes a lot of the discretion out of it, is what I'm saying. Is so if there's a coin flip where the judge doesn't really doesn't know either party very well and they have very limited evidence to go by, well, if one party tested positive for drugs, well, then that really, really tips the scales in the other direction. So, like I say, first hearing, temporary order, drug test, we come back. If there's no drug test, then we just jump in and we get into the meat of the actual case on that first hearing. So what we'll do on that day is we'll subpoena any witnesses that we need to attend that you don't think will attend freely. So if you have a neighbor that witnessed some sort of wrongdoing on the part of the opposing party, then we can subpoena them, especially if they have a job, they don't want to get in trouble, that type of thing. We can send out a subpoena. Or if you've had a CPS case involved with the opposing party, well, we can subpoena them and ask them to come and testify about what they observed, whether they talked to the child, that type of thing. If you've got family members that have witnessed the events in the household, if they can attend freely and you don't have a problem with it, then you can just let them know to be there. Of course, we will talk to the witnesses beforehand. We'll do it over the phone, but they may not need to be subpoenaed. And of course, you will be the most important witness as well as the opposing party. Those are the two big witnesses in any sort of custody case. And so what we're trying to show, like I said, is the best interest of the child. And we want to show in that first hearing that you've got a good setup. The child is doing well in school, if they are. We want to show that they're in a healthy environment and that this is the place that the child should stay at until we can get to the final hearing. And we'll do that by introducing the evidence that I mentioned. If you've got evidence of school records, of grades, if you've got records of you attending the parent-teacher conferences, all very helpful and very useful. Now, after that temporary order hearing, the judge will make a ruling. It's called an associate judge's report. And if you retained us on a full service basis, then we will go ahead and draft up a written, typed out rendition of that order and get it filed. And then if you represent yourself, then you'll use one of the forms that we've attached and you'll draft it up based on what they said, and then you'll get that filed. And after that, in Tarrant County, there's mandatory mediation. And so within about 3 months or so of that temporary order hearing, we will schedule a mediation. And both parties will attend, and I'll actually go through that right now. So the mediation can either be a half day or a full day. The half day is 4 hours, the full day is 8 hours. We have a lot of success in our mediations. About 90% of our cases settle there. And that's because we hire really good mediators, someone that's either practiced family law for a really long time, or often we hire retired judges who have served on the bench for years. And their perspective is really, really helpful in reaching agreement because they don't have any side. They're neutral. And so what will happen is we'll either have you come to my office on Belknap, on 701 Belknap, and then the other party will be there as well. We'll put them in a conference room. We'll put you in my office. And then the mediator will bounce back and forth between rooms. And the mediator will say, okay, well, based on my experience, based on the evidence that mom's telling me, based on the evidence dad's telling me, it sounds like, dad needs to compromise on this issue. Mom needs to compromise on this issue. And based on my experience, if you guys came to me and presented this type of evidence, this is what I would rule. And so it really creates an incentive for both parties to reach an agreement and both kind of compromise, give up some of the things they want, but hopefully retain what they really want. And that's what I always tell my clients is if you don't want to settle, you don't have to. You're the employer, I'm the employee. But if it's something that you can live with and you give the other side a little bit of a benefit, and you can reach a deal and save the cost of going to a final trial and also the risk of not knowing what could happen. I had it best explained to me once as having a mediator being able to use a scalpel in a surgery and really carve out exactly what it is each party wants versus going to a final trial and letting the judge use a meat cleaver. And so that mediation process, if it's 4 hours or 8 hours, it's $250 an hour for the lawyer. It's usually about $300 per each side, $300 to $500 for a half day mediation for the mediator, or just double that for a full day. And so then after the mediation, of course, we jump in. If we can't reach an agreement, then we'll jump into discovery, which can be a lengthy process, but we can keep it to a minimum to keep your bills down. If you want more discovery done, that's not a problem. We've had clients in the past that wanted depositions completed, that have wanted lots and lots of requests made for production on the other side, bank records. If you think that one of the opposing parties is hiding assets, that's your time to ask the questions that you think will elicit the testimony from the opposing side that you can use in the final trial. But if you're doing a plain Jane bare bones divorce, we can usually get through those requests for discovery with relatively minimal cost. And then we'll get prepped on that final hearing. The final hearing, it moves over to a district court judge. So it'll switch courtrooms, and we'll usually do a half day depending on how many issues are litigated. If there's tons of stuff going on, it may be a full day. And so the prices vary on that. But after the ruling in that final order, you do have time to appeal. You also can appeal the temporary order hearings. And so for more information on that, just go ahead and call our office and schedule a time to speak with one of the appeals attorneys. But after the final order, then that is a document that the judges signed and ordered that you'll use for the remainder of the children's career until they reach 18 or graduate high school. And so it's a very important document that will govern. If you do reach an agreement in mediation, then we'll draft up what's called a mediated settlement agreement. Both parties will sign it, and we'll enter it into the court, and hopefully the judge and the attorney general will sign off in some circumstances. And so that is a process. It's a 30,000 foot overview of a family law case involving custody or divorce. Now, the divorce, I mostly went over custody, but there's issues of temporary spousal support in divorce and factors that the court will use, and that is whether the parties have been married for 10 years or not. Another one is whether there have been wasting of community assets. Another one would be whether there's disproportionate earning power by the spouses. So if one party's a homemaker and doesn't have a lot of education, and one of them, the other spouse, makes a lot of money and is highly sophisticated, well, then both the temporary spousal support is an option under certain circumstances, as well as spousal support ordered afterwards for a period of time as well. In addition, if there is a disproportionate type of earning capacity, then sometimes in the temporary order hearing, the judge will order that the opposing party pay for your attorney fees if you're the disproportionate side of the party of the case. And that's because it's only fair, because if community property is used for, like, if the, let's say, husband makes a lot of money and he uses community funds from his wage, from his job, his wages, then those are community funds, and he hired a lawyer. Well, then it's only fair that you have access to those community funds to hire a lawyer to represent you. And so that's an overview of the process. Now let's go through timelines. So like I mentioned, after the documents are drafted, which usually take about 24 to 48 hours, we serve those documents, we set a hearing, we get in front of the judge within 14 days. If we do a drug test, then we come back in about another 2 weeks. If not, we go through the temporary order hearing, we get orders in place, we set the mediation about 3 months away from there. Then we go through mediation. If we can reach an agreement, we get the mediated settlement agreement signed. If we don't reach an agreement, then we go to final trial, which usually takes about a year from the date of that first temporary order hearing. Like I mentioned, there's about 3,000 cases on each judge's desk, so it does take some time to get in front of a judge for final hearing. And so it does take time. We get in front of them. It allows, if you're on a payment plan, it allows you to accrue some funds that we can use for that final trial. So that does help. And then you've got those temporary orders in place. Now, sometimes people get really, really concerned when they lose their temporary order hearing. If they're looking for primary custody, it's not the end of the world if you don't win your temporary order hearing and you don't get awarded primary custody. You can reverse that on final. It is possible. It happens. And so you got to really keep in mind that it's a long process and it can switch. So you have to be optimistic, and you have to keep acting in the best interest of the child or children. You have to document any instances where the opposing party isn't acting in the best interest of the child, and you use those and you combine those facts into a totality of circumstances that we will argue both in the mediation, the temporary order hearing, and in the final trial that it is in the best interest for the child to be awarded custody to you. So that is an overview of the process, and I hope that answers a lot of questions you may have. And so feel free to contact us if you need to speak with an attorney. And otherwise, stay tuned for more videos. I'll take you through more of the process next time. Thanks.